Good morning, good afternoon, or good evening, wherever you may be. Welcome to today's program, Understanding Interpol's Role in International Child Abduction, sponsored by the Family Law Section and International Section of the New York State Bar Association. The program will run for 1 hour, and participants are welcome to pose questions using the Q&A chat box in your Zoom portal. Without further ado, help me welcome from MK Family Law in Washington, D.C., Ms. Melissa Kucinski. Melissa?
Hi, welcome to our webinar today. I have not been so excited for a webinar in a long time. This is a topic that arises in almost all of my international family law cases in some way, but I have rarely known where to turn for good, solid legal advice. But today, now I have two brilliant attorneys to refer my cases to. So I am so honored to introduce you to our two speakers. And if we go to the next slide, you'll see their bios. Today, we're joined by Charlie Magri, a lawyer based in Marseille, France. Prior to founding his law firm, Charlie was a legal officer at the Secretariat to the Commission for the Control of Interpol Files. This means he was involved in processing requests from individuals who sought to delete their data from Interpol files. His law firm specializes in challenging Interpol notices and defending individuals affected by them. And I was pleased to be introduced to Charlie by another amazing lawyer, Sandra Grossman. Sandra is an immigration lawyer and founding partner of her firm, which is located in Maryland. A portion of her practice involves representing and supporting clients before Interpol, and she has significant expertise representing clients before U.S. consulates worldwide in immigrant and non-immigrant visa applications, administrative processing, and waivers of inadmissibility. So it's without any hesitation that I say that these two lawyers are the experts on this topic, and the New York State Bar is truly honored to welcome them. Before we start and I turn it over to them, please know that you can post questions in the Q&A that I am going to monitor throughout the program, and that Sandra and Charlie have saved a little time at the very end where I can then present as many of the questions as I can, which I may reformulate and may combine at the very end. So please use that function and I'll be monitoring it. So I'm going to let Charlie and Sandra take it from here.
Thank you, Melissa, and thanks to the New York State Bar Association for inviting us. We're very excited to be here today to delve into a topic that eludes many and that many may find themselves unfamiliar with, but one that can play a pivotal role for our clients in cross-border law enforcement, and that is Interpol's involvement in international parental child abduction cases. So this session is going to take you through how Interpol operates, its specific role in cases of international child abduction, and the legal framework governing Interpol's action. First, we're going to provide a foundational understanding of what Interpol is and how it works. Then we'll move on to the specific procedures for issuing red and yellow notices, which are often the kind of notices at play in these kinds of cases. We'll discuss the avenues available for challenging or deleting these notices, and especially in cases involving parental child abductions. And then we'll end up with a Q&A. So let's start by taking a closer look at Interpol. So first, to start with just a very brief overview, Interpol is an international intergovernmental organization with 196 member states. It has a long and sometimes dark history. It was created in 1923. And contrary to what all those Hollywood films tell us, it is not an international police force. It does not have arrest powers or even investigative capabilities. Instead, what Interpol really is an information sharing platform which coordinates and facilitates cooperation among law enforcement agencies worldwide. And its purpose is to combat transnational crime. So again, the role is really facilitated by enabling countries to exchange data through Interpol channels, which it often does by publishing notices and diffusions. So important to remember, no authority to arrest individuals. Arrests are actually conducted by national law enforcement agencies, which act on their on the basis of their own legal systems and processes. Second, no investigative capabilities, just the sharing of information. And third, it's important for people to know that Interpol is not affiliated with the United Nations. It operates entirely independently according to its own legal framework. And then very briefly, so that we know what we're dealing with, let's discuss Interpol's organizational structure. So first, there's the General Assembly, which is Interpol's supreme body, responsible for setting policies and the organization's direction. It meets annually. It's about to meet again, actually, in, I think it's early November. There's an executive committee, which oversees the implementation of the General Assembly decisions and meets approximately 3 times a year. Then there's the General Secretariat, which manages Interpol's daily operations and coordinates global law enforcement efforts. And then lastly, and probably the one we'll spend most time with today, is the Commission for the Control of Interpol Files, or the CCF. So the CCF is located in Lyon, France, close to where Charlie lives, and it's an independent body charged with ensuring that Interpol's data processing, in other words, the requests for police cooperation made by member states, are actually in compliance with Interpol's rules and constitution. We'll get back to more information on the CCF later. So let's talk a little bit about a really important component of Interpol, which are the National Central Bureaus, or what we refer to as the NCBs. So each member country of Interpol operates an NCB, which basically serves as the main point of contact between Interpol and the country's law enforcement agencies. Here in the United States, the NCB is located in Washington, D.C., close to me, and is co-administered between the Department of Justice and the Department of Homeland Security. NCBs play a critical role because they are actually the entities that can request the issuance of a red notice, a yellow notice, any kind of notice, as well as the other types of alerts that help coordinate international efforts to locate and arrest individuals or find missing persons. So now I'm going to pass it over to Charlie to talk about the legal framework that underpins Interpol's activities. This is essential to all of us lawyers and our clients because understanding the legal framework defines how Interpol operates and the rules that it must follow when processing data. Charlie?
Thank you, Sandra, and good morning, good afternoon, or good evening, depending on where you are. Welcome and thank you for joining today's webinar. So let's begin by discussing Interpol legal framework. So Interpol operates under its own set of rules, which include its constitution, the rule on the processing of data, the RPD, and various General Assembly resolutions. So it's important to note that also Interpol is not established by an international treaty. It still respects widely accepted principles of international law, such as the Universal Declaration of Human Rights. First, we have the Interpol's constitution. So Interpol's constitutions contain 2 key articles that shape its operations. Article 2 outlines Interpol core mandate, which is to promote the broadest possible mutual assistance between police authorities of its member countries. However, this must always be done in accordance with national law and the Universal Declaration of Human Rights. And Article 3 is what ensures Interpol's neutrality. So it explicitly prohibits the organization from taking part in activities or interventions of a political, military, religious, or racial nature. So this is really crucial to keeping Interpol focused on law enforcement cooperation without the influence of external political or ideological pressures. So next we have the Interpol's rules on the processing of data, so the RPD. So the RPD establish the framework for how Interpol collects, stores, shares, and uses data for international police cooperation. So these rules ensure that data is processed lawfully, accurately, and for legitimate law enforcement purposes. They also regulate data retention and sharing with member states or other entities, like private entities or other international organizations. And next, we have the statute of the Commission for the Control of Interpol's Files. So the CCF is an independent body within Interpol. It is responsible for ensuring that all personal data processed by Interpol complies with the organization rules. In 2017, the CCF statute came into effect, greatly reinforcing the CCF's power. The CCF is tasked with examining and deciding on requests for access, correction, or deletion of data within the Interpol information system. So in this capacity, the CCF play a crucial role in handling complaints from individuals who believe a red notice diffusion or other alert for cooperation have been unjustly issued or who seek information regarding such notices. So if you need to determine whether a notice has been issued against your client or wish to challenge its validity, the CCF is the competent body to address this request. So now that we have an understanding of Interpol legal framework, let's move on to how this framework applies in practice. So especially in cases involving red notices. Red notices are often used by Interpol or in cases of parental child abduction to locate and provisionally arrest the abducting parents, pending legal action such as extradition. But what are the criteria for issuing a red notice? What must be in place for a notice to be valid? And what are the implications for the individual involved? So let's explore this question in the next session, and I will pass it over to Sandra for the next section.
Thank you, Charlie. Exactly. So we're going to get into the meat of the presentation now that you have some background, which is red notices. So what is a red notice? A red notice is one of Interpol's most well-known types of cooperation and data sharing. The primary purpose of a red notice is to alert law enforcement agencies worldwide about a wanted individual. It requests that the authorities in any particular country where that individual may be found locate him and, if appropriate, under their own national laws, provisionally arrest them pending an extradition. So in the context of parental child abduction cases, a red notice may be issued for a parent who has unlawfully taken or kept their child in another country, thereby violating custody or legal agreements. There are some myths about red notices that we should discuss. A red notice is not an international arrest warrant. It is a request, not a command. And the power to arrest rests entirely with national authorities based on their own legal frameworks. In the US, for example, a red notice does not confirm the sufficient level of probable cause needed to arrest someone. Though, just given my background in immigration law, I do think it's pertinent to note that for non-citizens in the United States, immigrants and residents, a red notice can and often does lead to a civil enforcement action through US immigration agencies. I just wanted to note that it's the topic of another session, but that's how the US handles red notices. So lastly, it's important to note that being listed on a red notice does not mean you are guilty of a crime, because a red notice can be issued either to face prosecution, so for a person who has been charged but not yet been found guilty, or to serve a sentence if they have already been convicted in a national court. So the actual determination of guilt or innocence occurs in a court of law, not through the issuance of a red notice. And finally, just some interesting statistics. Not all red notices are publicly available. really only a small percentage, about 10%, are published on Interpol's public website. And these are typically cases where the assistance of the public is deemed necessary to locate the individual. As of now, there are about 70,000 active red notices in circulation, but only 7,000 are publicly available. Most of these red notices that are not publicly available are circulated confidentially among law enforcement agencies. So we turn to the next slide, which is who exactly can request a red notice and who can actually issue it. So only Interpol member countries, again, through their NCBs, their national central bureaus, in the US's case, administered by DHS and DOJ, can request a red notice. And they have to submit a formal request to Interpol backed by a national arrest warrant or court order. So the red notice should not automatically be issued upon request. It is reviewed and authorized by the Interpol's General Secretariat to ensure that it complies with Interpol's rules, particularly what Charlie briefly mentioned, which is Article 3 of Interpol's Constitution, which, as a reminder, prohibits Interpol from engaging in activities of political, military, religious, or racial nature. Here, I just want to acknowledge again that sometimes these requests do fall through, and requests that should not be issued are issued. So in any case, if it meets all of the necessary criteria, or Interpol believes that it does, they will publish the red notice, which is visible to all member countries. So what are the minimum criteria for issuing a red notice according to its rules? So red notices are used for serious offenses with accurate, verified information. So there must be an arrest warrant or a court decision issued by a competent judicial authority. The seriousness of the offense is another key requirement. So according to its rules, Interpol should not issue red notices for minor offenses or matters related to cultural norms, private disputes, or family matters, unless they involve organized crime or some significant criminal activity. Again, in practice, Interpol does issue some notices that don't meet these requirements. So for a red notice to be issued, just to be clear, what's a serious offense, right? So the person must be wanted for an offense that carries a penalty of at least 2 years of imprisonment if they're wanted for prosecution. If already convicted, that person must have been sentenced to at least 6 months of imprisonment or have at least 6 months remaining served. Lastly, and this is important too, the request that's coming from any particular NCB has to contain sufficient identifying information about the individual, such as their name, nationality, physical characteristics, as well as a clear description of the offense and the charges that that particular person may face, as well as the relevant legal provision under which they're being pursued. This is important to understand because later when we talk about challenging or deleting red notices, we can do that by arguing, for example, that there is no clear description. Charlie?
Thank you. Now the part about the specific condition that must be met in cases of parental child abduction. So as previously mentioned, under Article 83 of the PD, when notices may only be issued for serious ordinary law crimes. So in January 2022, the General Secretariat of Interpol added parental child abduction to a non-exhaustive list of offenses that typically do not qualify for red notices, provided that specific conditions are met. So under this rule, red notice cannot be issued for parental child abduction if there are conflicting custody decisions between courts in 2 different countries, and as a both parents participated in legal proceeding in both countries, or if that's not the case, the custody dispute is involved in High Convention proceedings, and these proceedings can be ongoing or concluded, and custody was granted to the parent targeted by the red notice. So these conditions are in place to prevent the misuse of Interpol red notice system in complex cross-border custody disputes. So the goal is to ensure that the system is not used to unfairly influence unresolved custody disputes, or where one parent has been awarded custody through High Convention proceedings. Now, all of that said, sometimes when notices do slip through the cracks and notices can be issued where these conditions are met. So now let's now turn to the impact of a red notice, particularly in cases of parental or child abduction. So a red notice issued by Interpol carries significant legal, social, and economic aspects. Let's take a closer look at the most important aspects. So first and foremost, also a red notice is not an arrest warrant. Many countries treat it as sufficient grounds for provisional arrest. So this often leads to extradition proceedings, where the individual is transferred to the requesting countries to face prosecution or serve a sentence. When notices also impact border control, obviously. Individuals flagged by a red notice are entered into global border control system, which can trigger alerts when they attempt to cross international borders. So this often results in them being detained at airports, border crossings, or other entry points by local authorities. And additionally, a red notice can lead to visa restriction, making international travel extremely difficult. And the consequences of a red notice are not just legal, but also reach into social and economic aspects. Being subject to a red notice can create significant employment issues, particularly for those working in sectors that require security clearance or frequent international travel. Financial institutions, especially those following know your customer and anti-money laundering regulations, may freeze accounts or even refuse services. So this limits access to loan or credits, especially from international banks. Perhaps one of the most far-reaching impacts is the damage to one's reputation. Because being the subject of a red notice implies that the individual is wanted for serious offenses. And this often results in public perception that fails to differentiate between being wanted and being convicted, leading to long-term damage to both professionally and personally. And now, if an individual has been arrested based on a red notice and extradition proceedings have begun, there are two main outcomes. If the court approves the extradition request, the individual will be transferred to the requesting country to face prosecution or serve the sentence. On the other hand, extradition may be denied if there are political motivation or, for example, concerns about human rights violation or insufficient evidence to justify the extradition. So in such cases, the individual is typically released from detention. However, it's really important to note that even if extradition is denied in one country, the red notice remains active within the Interpol system. So this means that the individual still faces the risk of detention or extradition in other countries, making future international travel risky and dangerous. I will turn it over to Sandra for the next section.
Thank you, Charlie. So in this next section, we are going to explore how yellow notices are utilized in international parental abduction cases, including the procedures for their issuance, the implications of a yellow notice once it is active, and what exactly happens when a missing child is located at a border crossing. So let's begin by breaking down the key aspects of a yellow notice. from their purpose to the procedural steps followed when a child who's the subject of a yellow notice is actually identified. So first, what is a yellow notice? Basically, it's an international arrest alert. A yellow notice is an international alert issued to help locate missing persons, particularly children who may be victims of parental abductions, criminal abductions such as kidnappings, or unexplained disappearances. A yellow notice can also be used to identify individuals who are unable to identify themselves. And this may occur, for example, when the person is found, but for some reason cannot communicate their identity due to reasons such as mental health issues, age, trauma, or other language barriers. So while some of the yellow notices are restricted to law enforcement use only, many are available publicly. So as of December 2023, there are approximately 16,394 valid yellow notices in circulation, with about 9,800 of them publicly accessible. So under what circumstances can a yellow notice be issued? Basically, just like red notices, there are certain conditions that must be met, but this time we look at Article 90 of the Rules on the Processing of Data. So first, there has to be a police report. The disappearance or discovery of the child or person must have been reported to the police. Second, the whereabouts of that missing person or the identity of the discovered person must also be unknown to the police. Third, there are privacy considerations. If in the issuance of the yellow notice, missing person is an adult, you have to consider applicable national privacy laws that allow for the issuance of the notice, whether or not that notice is valid in any particular country where the person is found. And there also have to be sufficient identifiers, as is the case with red notices. So there must be sufficient data about the person or the circumstances surrounding the disappearance or discovery to allow for that person's identification. So this is going to include details such as physical description, photographs, DNA profiles, or fingerprints. And then finally, yellow notices are issued when there are cross-border concerns, meaning that international cooperation between different countries is necessary to locate a missing person. So how can clients request a yellow notice if their child has been abducted? Basically, they would follow these steps. First is to report the abduction to local law enforcement, because again, individuals themselves cannot request a red notice or a yellow notice from Interpol. It is the law enforcement agency that will work with that particular country's NCB or National Central Bureau to submit a request for a yellow notice to Interpol. And they will provide the necessary documentation and detail. And then finally, there's a step which involves coordination with Interpol. So that particular NCB will coordinate with Interpol to issue the yellow notice, which will then be circulated internationally. So turning now to the implications and effects of a yellow notice. Just like red notices, there are significant implications, both for law enforcement and for the individuals that may be the target of these notices. So again, it's circulated across all of Interpol's 196 member countries. This makes it a fully global alert. It flags the missing person also in border control systems. So this means that if the individual, particularly a missing child in this case, tries to travel, tries to cross an international border, whether alone or with a parent, immigration or customs officials will be alerted. The child's movements can be restricted, and authorities will take certain steps to detain the child and ideally protect them from further harm. So in the next slide, we can discuss what happens when that child is identified at a border crossing. It's important to note as we discuss this that this can vary depending on what country the child in and whether the national authorities of that particular country decide to act on the yellow notice or not. So this slide covers what happens when authorities do decide to take action. The first thing is that they will confirm the child's identity. They'll use the travel document, the passport, photos, and other identifying information that they received from the yellow notice. Second, local law enforcement or immigration officials, including U.S. Customs and Border Protection here in the U.S., are alerted. And then the NCB coordinates with those relevant authorities in the child's country of origin. If these actions are taken, the child could be placed under Child Protection Services while the case is being reviewed and handled by local law enforcement. Then authorities will check the custody rights and the legal standing of the adult that's accompanying the child in that particular situation. If the adult is not the parent or legal guardian or is suspected of actually being involved in the abduction, then that individual may also be detained. So if necessary, consular services and child protection agencies will work together, if appropriate, to repatriate the child. Again, it's critical to understand that the effectiveness of these steps depends on the particular case and whether that particular country's law enforcement chooses to take action or not. So in the next slide, we'll discuss what happens once the child is returned. So if the missing child is safely returned to their legal guardian, it's the responsibility of the National Central Bureau that originally requested the yellow notice to inform Interpol and to request cancellation of the notice. So these are just some of the complexities of issuing red and yellow notices. And we now want to turn to the practical aspects of challenging these notices again before the CCF, the Commission for the Control of Interpol's files. This is really important for this audience because for lawyers and their clients, as well as their clients' children, if they feel like they've been the wrongful target of, say, a red or yellow notice, it'll be important for those stakeholders to understand the legal strategies involved in trying to challenge or delete one of these notices. Charlie?
Thank you, Sandra. Now that we covered the complexity of issuing red notice and yellow notices, particularly in case involving child abduction, it's crucial to understand how this notice can be challenged before the CCF. So what is the CCF and what is the role of the Commission for the Control of Interpol's files? So as we said, the CCF is an independent body that ensures that all personal data processed through Interpol channels conform to the organization's rules. So it acts as the primary mechanism for individuals who believe a red or yellow notice has been unjustly issued, or if they are just seeking access to information about any such notices. So one of the most important aspects of the CCF, and it's really important, it's independence. So the CCF operates independently and completely separately from Interpol General Secretariat and Interpol's member countries, ensuring that decisions are made without external influence or pressure. The members of the CCF serve in their personal capacity, meaning they do not represent any national government or law enforcement agency or outside interest. And this would prevent undue influence on the decision-making process. And in addition, members must recuse themselves from cases where there might be conflict of interest, such as cases involving their home country. So, for example, a French CCF member should recuse himself from a case involving a red notice issued by the French authorities. The CCF is composed of 7 members and is divided into 2 main chambers. So the request chamber is tasked with reviewing individual requests for access, correction, and/or deletion of data in Interpol databases, such as red or yellow notices. And there is also the supervisory and advisory chamber, which focus on broader issues, such as advising Interpol on data protection policies or new Interpol police projects. And currently, the CCF hold 4 sessions per year, each lasting 5 days, where members review cases, deliberate, and make decisions. Another important aspect is to understand that the CCF mandate is limited to overseeing that data within Interpol information system. And it's really important again. So its primary function is to ensure compliance with Interpol legal framework. However, the CCF cannot conduct criminal investigation, assess the merits of individual criminal cases, or intervene in national files, immigration matters, or extradition proceedings. So these matters are handled by national authorities and fall outside the scope of the CCF work. So now if an individual believes that a red or yellow notice has been unjustly issued, they can submit a request for deletion to the CCF. And this process begins with a formal complaint submission. And once the complaint is received, the request chamber initiates a review to assess whether the notice complies with Interpol's rules on international legal standards. And to ensure an informed decision, the CCF typically consults with the National Central Bureau, so the NCB, that originally requested the notice. So this is the source of the data. And the NCB is often asked to provide input on the applicant's arguments, ensuring that both sides of the case are taken into account. Another important point, the CCF decisions are binding, so Interpol must follow and enforce them. If the CCF determines that the notice violates Interpol's rules, it can take the following action. So the notice can be removed entirely from Interpol's databases, or the CCF may require corrections to ensure the accuracy of the information in the notice. Or in some cases, the CCF may block the notice from being circulated among Interpol member countries until further review. And once a decision is made, Interpol must follow the CCF decision to fix any non-compliant data. And Sandra, over to you to explain the difference between request for access and deletion.
Thank you, Charlie. So individuals that are dealing with Interpol data, like red and yellow notices, have 2 primary options. They can either request access to that information or request deletion of that data. So a request for access to information allows individuals to find out if Interpol holds any data about them, such as a red or yellow notice. So the idea is to give them access to that data so that they can understand the allegations against them. So the CCF typically responds within 4 months to those requests, although these days there appears to be significant backlogs, and it can be sometimes even 6 months, which can be extremely frustrating for individuals that are seeking to defend themselves against charges that they may deem to be unjust or improper. With a request for deletion, that individual is seeking the removal or deletion of, for example, a red notice against them when they believe that that notice has been issued in violation of Interpol's rules or constitution. So in that case, an applicant would present to the commission the specific legal grounds indicating which one of Interpol's rules and constitutions have been violated. It's important to know that anyone can file, any private individual or their lawyer acting on their behalf can file a deletion request or a request for access with the CCF. The CCF has a robust website that explains their policies and procedures. I will say that this is complicated. As you can see, there's a lot of information that we're sharing with you in a very short period of time. And definitely having the legal expertise and experience with Interpol and its structure and foundational documents can significantly improve the chances of success. So if you file and the CCF determines that the notice that you are requesting deletion does not comply with Interpol's rules, it will be deleted from Interpol system, and you will receive a decision reflecting that process. That process typically takes around 9 months, although again, during this time, we're seeing longer delays due to the high volume of cases. Charlie?
Thank you. Now let's dive into the jurisprudence of the CCF regarding parental child abduction cases, looking first at red notices and then at yellow notices. So concerning red notices, so as previously mentioned, since 2022, the General Secretariat of Interpol has maintained a list of offenses for which red notices cannot be issued, with parental child abduction included under specific conditions. So these guidelines are central to the CCF review of red notices in such cases. So when evaluating a red notice related to parental child abduction, the CCF examines whether there are conflicting custody decisions between courts in two countries and check if both parents participated in legal proceedings in both countries, or if the custody dispute is either ongoing or resolved under the Hague Convention. So if these conditions are met, the CCF typically deems the red notice non-compliant with Interpol rules. Decision except related to parental child abduction cases can be found on Interpol's public website. However, this decision predates the 2022 list of offenses published by the General Secretariat and may not fully reflect the current approach of the CCF. So now let's move on the CCF jurisprudence on yellow notices. So when reviewing yellow notices in parental child abduction cases, the CCF primarily looks at whether the notice has fulfilled its purpose. So typically to locate a missing person. And one of the most compelling arguments for challenging a yellow notice is proving that the child location is already known to the national authorities. If the child location is identified, the yellow notice may be considered to have served its purpose and could be deleted. So in the 2017 case, the CCF found that authorities had already shared the children location between two countries, and also the children weren't with the father. They were not considered missing. As a result, the CCF decided that the yellow notice was no longer needed. In a 2018 case, the CCF found that national authorities knew the child location and had regular contact with them. And the CCF decided that the yellow notice had likely served its purpose. However, the CCF noted that the notice could remain active if the child were to travel internationally. And more recently, in 2024, the CCF confirmed this reasoning in a new decision. Also the applicant claimed that the child location was known. The CCF upheld the yellow notice, stating that the child exact location had not been established, and the abducting parent might wish to travel with the child internationally. So in summary, demonstrating the child location is a strong argument for deletion, but each case is evaluated individually, and proving the child location does not automatically lead to deletion, especially if there is a possibility of international travel. So My advice for challenging a yellow notice is to focus on proving the exact location of the child and argue that there is no real risk of international travel. So while obtaining this kind of evidence can be difficult, obviously, it makes your case much more effective. So you can, for example, argue that the child does not possess a valid passport or travel document. You can provide proof that the child is enrolled in school and show a stable ongoing presence in the country. You can demonstrate that the parent in question has strong ties to the current country, such as family or employment, making less likely that they would attempt to flee internationally. So what happens when the CCF finds that a red or a yellow notice does not comply with Interpol's rules? Now, when the CCF finds a red or yellow notice non-compliant with Interpol's rules, the data is deleted, and the process is as follows. So the CCF first communicates its decision to the Interpol General Secretariat, which has 1 month to delete the data from its systems. And the General Secretariat informs all NCB that the data has been deleted in compliance with the CCF decision. And it also warns that any further international cooperation through Interpol channels on this case will violate Interpol's rules. Then NCB are also instructed to update their national databases and ensure that all national entities, such as police and border control, do the same. And at the same time, the CCF informs the applicants and provide them with a copy of the decision confirming the deletion of the data. And now that we've explored the issuance and use of yellow notices in parental child abduction cases, let's transition into understanding the practical step practitioners should take when challenging yellow or red notices before the CCF. So in the next section, we will provide practical tips and best practices to ensure your submission are well prepared and improve the chances of favorable outcome. And Sandra, I give you the floor.
Thank you, Charlie. And in the spirit of trying to get to the questions, I'm going to sort of fly through this section, and we'll talk about how you can best advocate for your clients when making a filing for the CCF. So first, important to understand the mandate. The CCF's role, the CCF is not a court, right? So they're not going to evaluate the merits of the case or resolve legal disputes. They're strictly going to adhere to Interpol's rules and constitution and issue a decision based on whether a particular red or yellow notice is compliant or not with those rules and constitution. You want to structure your legal arguments around those violations. For example, you might emphasize Article 2, human rights violations, or Article 3, prohibition on political, military, religious, or racial involvement, if you think that those arguments make sense in your client's cases. When dealing with child abduction cases, you want to highlight the conditions established by the RPD. So, for example, with a red notice, you could discuss whether conflicting custody decisions exist and whether one or both of the parents participated in the legal proceedings in both countries involved. For a yellow notice, you can emphasize the purpose of the notice, as Charlie said. If the child's location is already known, you argue that the yellow notice is no longer necessary. You want to ensure that your submission demonstrates the violation of the rules. So, for example, if conflicting custody decisions exist, provide evidence of that, such as court orders or custody rulings. Finally, make sure that you're monitoring time frame. Again, 4 months for access requests and 9 months for deletion requests. So make sure that your submission is timely, that you're responding timely if the CCF gives you deadlines, and all of this is going to help avoid unnecessary delays for your clients. So now that we've covered these steps and best practices, we can move on to questions and answers. Thank you all.
So Charlie and Sandra, we had about 6 questions come in, so I'm going to start running through them. Can Interpol issue a red notice only upon request of a country if there's no arrest warrant?
It's as a go ahead, Sandra, as you want.
Oh, please, go.
It says based on a valid arrest warrant or a court decision. So it's either one court decision or arrest warrant. That's all.
What type of evidence would be required to show cross-border involvement for the purpose of requesting a yellow notice?
Basically, for example, that one parent or legal guardian may have taken the child out of the country where that child is living with their other parent or legal guardian and moved them to another country. So in that case, you need to file a yellow notice to locate that child.
Do you need to have evidence that the child's located in a particular country?
I would say that it's so, again, because a request for a yellow notice or a red notice is disseminated to 196 member states, it goes to all of those member states instantaneously. If you don't have evidence of where they are, you would note that, and I guess it would add to the validity of the request. I think it helps if you understand what country they're in, because the authorities of that particular country would be more likely to pay attention to the request.
So in a child abduction case, the parent's ideal goal is to actually repatriate or return a child. For these Interpol notices, would either a yellow or a red notice have any effect in helping return a child, or is it just primarily at best to locate a child?
It's a good question. Actually, I think it's really depend of the national laws where the child is located. It really depends of the action taken by the border authorities or the police officers. It really depends of the country where the child is located.
In making a request for an access to information or a request for deletion of a notice, does that have to be done by anyone specific, say like an international lawyer in a specific country?
No, it can. I mentioned this. It can be done by an individual who is not a lawyer, who believes that they or their child may be the target of a red notice or a yellow notice, or it can be done by a lawyer who specializes in these kinds of cases. A request for access is a fairly simple endeavor. And if you go to the CCF website, there are clear instructions on how to file a request for access. I would say that a request for deletion of a particular notice is a more complicated endeavor, and it'd be helpful to hire attorneys that understand Interpol jurisprudence.
What is the current waiting time for the CCF final decision over a complaint nowadays, from the time a complaint's accepted to the deletion of the notice, if you know?
So in my experience in recent cases, including cases that Charlie and I may be working on together, once you make a request, it usually takes about a month to 6 weeks or so for the Commission for Control of Interpol's files to find your request admissible. And then after that, if what you've done is requested a deletion, it's supposed to take 9 months, but what we are seeing is that it takes more like a year to even a year and a half.
And then the commissions need has 1 month to forward its decision to the General Secretariat of Interpol, which has 1 month to implement the decision, and eventually the CCF has 1 month to inform the applicant. So there are 3 additional months in the request. So overall, more than a year for sure.
So I have perhaps a more legal question. There was a slide that indicated if there were 2 custody decisions, that has an impact on what's happening. But what if the two custody decisions where one of them involved proceedings where a parent just didn't participate? Maybe they didn't have notice. Maybe it was a sham proceeding of some sort. Does that have any impact on whether a notice might be issued, deleted?
I think so. It could be an argument. It depends.
The lawyer answer, it depends.
Yeah, no, I don't want to give an inaccurate answer. So let me back to this slide. So just to summarize, a red notice cannot be issued for a parental child abduction offense if there are conflicting custody decision in two countries. So if one parent does not participate, I think that the red notice can be published because one condition will not be met in that case. And it will be, it depends whether you want to challenge the notice or not. It depends on which side you are.
Yeah, I mean, I agree with that. So I think the idea is right, that Interpol under Article 2 of its constitution is supposed to act within the spirit of the Universal Declaration of Human Rights. Part of that, Melissa, is that you have a right to a free and fair defense, right? That you have a right to due process. And if you are a parent that did not have the opportunity to participate, substantively in proceedings about your own child, or you are facing criminal accusations, again, that you did not have the ability to participate in, those would certainly be arguments that you could make to the CCF for the purpose of deletion.
Assuming you determine that eventually that there was some proceeding and that it handed down some type of order, because you might not know about it, at least initially.
And I suspect, Melissa, that happens in parental abduction cases. There are parents that are not even aware of decisions from other countries. Yeah.
Right. Absolutely. So this last question that popped up is one that I'm not entirely sure I understand. So I'm going to ask it as it was written, and you can determine how you want to answer it. Do red and yellow notices fall under the concept of a diffusion, or is a diffusion something different?
It is. It's something different. Charlie, do you want to address this, or?
Yeah, red notices are circulated to all member countries of Interpol, so 196 countries. And diffusion have the same effect, but they are circulated only to specific countries. So, for example, you can send a diffusion to only, let's say, 10 countries, while the red notice will be automatically sent to all countries of Interpol. But the rules are almost the same. The CCF apply mutatis mutandis the rules for the red notice to diffusions.
And it's my understanding, Charlie, that there's some additional vetting that's supposed to happen for at least a priori for a notice versus a diffusion. So diffusions are sort of easier for any particular country to issue, at least preliminarily. Is that correct?
Yeah, they are all, both diffusion and red notices are controlled by the NDTF, so the Notice and Diffusion Task Force. So red notices are published prior to their publication, but diffusion are also reviewed, but the message is already sent to member countries. And if eventually the NDTF find that the data is non-compliant, it will be deleted, but the message is already sent to countries. So they should not act based on this diffusion, but already sent.
Well, I have that our hour is up. So I just want to thank Charlie and Sandra. You did an extraordinary job. You kept it focused on child abduction, which is so important to all of us that logged in. And so I'm really, really grateful. On the final slide, your contact information was listed. And for those who may have asked this question, the NYSBA, New York State Bar, will send out an email. It will include a link to the recording for today's webinar. So you will have every piece of information that was shared today coming by email at some point soon. So thank you very much, everyone. Cara?
Thank you.
Thank you so much, everyone. Thank you, Melissa, Sandra, and Charlie, for this very informative and very detailed webinar. I'm sure all attendees learned a lot, especially me, who's not even in the field, but has definitely enjoyed this program. Thank you also to our attendees. As Melissa said, I'll email you the recording once it is available. Thank you and enjoy the rest of your day. Thank you.
Thank you.
Thank you.